All right, class, welcome back to our final discussion of shareholders. And in this portion of the presentation, we're going to discuss shareholder lawsuits. All right, and so we begin with the the idea that directors, as the overseers of the company, have the ability to file lawsuits if the corporation is wronged by a third party. If the directors fail to do so, the shareholders, as the owners of the company, actually have the right to do so derivatively. Right? This is known as a shareholder derivative lawsuit. And it becomes particularly important when the wrong that the shareholders allege arises from within the company or at the director level. And here I should note that shareholder derivative suits are in the form that we know them in the United States, are very particular to the United States. Other jurisdictions limit a derivative type of shareholder lawsuit, or just don't conceive of it in the same way. Germany, for example, rates the rights of employees and company duties to employees just as significant as shareholder rights. So there is no notion of shareholders derivatively suing the corporation. In Great Britain, or I'm sorry, the United Kingdom, they don't authorize shareholder derivative actions, and shareholders would only bring that type of suit in a case where the shareholders couldn't have legally authorized that type of action. And Japan, it permits a version of shareholder derivative lawsuits, but if the plaintiff loses, the company can sue the plaintiff for damages, which is very interesting. It means that in none of these other major jurisdictions are shareholder derivative suits used as extensively as they are in the United States, where they are the most common type of lawsuit against corporate directors. So, one point to remember is that a shareholder derivative lawsuit is always going to be made after a written shareholder demand that the company do something about whatever the wrongdoing is, right? So the way that this would arise is that the shareholder becomes aware of some situation for which they think the corporation needs to act, right? And then they make a demand, and then under the Revised Model Business Corporations Act, which is a uniform law which states have adopted, the board would have 90 days to respond or to take appropriate action. That appropriate action could involve a lawsuit initiated against the appropriate party, or it could be whatever appropriate action the board deems appropriate, if in fact it resolves the issue, right? The derivative lawsuit only arises if the board does not take appropriate action. So if they don't initiate that lawsuit, or if they don't take some alternative that also addresses the issue. So the derivative lawsuit will be dismissed if the board takes appropriate action. Similarly, the derivative lawsuit would also be dismissed if, for example, the majority of the board of directors, using their business judgment and subject to the business judgment rule, right, determines that that action in that case would not be appropriate, or some alternative is appropriate, right? Again, that would be subject to some scrutiny, but again, they're going to defer to the board if it was made in a proper fashion. Another point to be considered is that the damages that may be recovered in a derivative lawsuit go to the corporation, not to the shareholder that initiates the lawsuit, if there are damages. These cases can be about more than damages, but the damages don't represent losses that are suffered by the shareholder. The damages represent losses that are suffered by the corporation. So in the book's example, they say Xeon Corporation is owned by two shareholders, each holding 50% of the corporate shares. One of the shareholders wants to sue the other for misusing corporate assets. In this situation, the plaintiff shareholder will have to bring a shareholder's derivative suit, and rather than a suit in their own name, for the reason that I just stated. They're not the person that's suffering, even though long term, obviously as the owner, the waste of corporate assets impacts the shareholder, right? That's a claim of the shareholder against the corporation, right? The injury to the corporation, which is a separate legal person, was suffered by the opposing shareholder. All right, so because the harm was suffered by the Xeon Corporation and not by the plaintiff, any damages awarded will go to the corporation rather than to the shareholder, right? So ultimately, in a case like that, that might result in the corporation being dissolved after that. Who knows? Then those damages might be distributed to the shareholder, right? In other situations, a shareholder derivative lawsuit can be about other things entirely. For example, in the film Barbarians at the Gate, which we watched, that was essentially a board level fight about a change in control transaction being, the leveraged buyout of RJR Nabisco, right? But suppose that instead of a direct tender offer, it was a hostile tender offer, right? Which were more common back in those days. I don't know that I've seen one in recent memory, but there were times, let's say, they didn't arrive at an agreement with the board about price and what have you, and the board didn't want to sell. They were being obstreperous. You could solicit proxies from the shareholders, right? And suppose that the parties, parties feel that they're being dealt with improperly, right? Someone doesn't get what they want. Derivative suits can impact proxy fights, right? In various ways. So it's not always about damages. Sometimes the consequences of a shareholder derivative fight might be that one party or another gets to take control of a company. The importance of shareholder derivative lawsuits is the proliferation throughout the United States, right? And some of the concerns include the ways in which shareholder derivative lawsuits have been used in these contentious situations. So, I looked up a few of the common reasons that these lawsuits come into play. And number one is breach of fiduciary duty. So the managers / directors of a corporation have a fiduciary duty to act in the company's best interest, and a failure to do so may result in a shareholder derivative lawsuit. Certain conflict of interest transactions, and I want to be careful about talking about this one. It's not as if directors can't engage in business with the corporation. For example, they may also be employees of the corporation. That's not a conflict of interest. They may provide services for the corporation. That's also not necessarily a conflict of interest. But the law prohibits shareholders from putting their interests ahead of the interests of the corporation. That doesn't mean you can't charge a fair rate for your services and earn a profit if you're providing services, right? So I just want to put a star on that one. So conflicts of interest, breach of shareholder agreements, so they define the owner's rights and obligations. I think we've mentioned that before, and they are bounded by the articles of incorporation. Of course, that would also result in a shareholder lawsuit directly as opposed to just a shareholder derivative lawsuit. Um, uh, Certain types of corporate actions, like failing to for the corporation to take its obligations seriously, like companies that don't pay taxes or that have record keeping or accounting irregularities, failure to have a business plan, to take a business make a business decision that within the that sort of exceeds their ability to take corporate action, like known as ultra virus, that sort of go outside the articles of incorporation or permitted actions for a corporation. So if it involves the contractual and statutory rights of shareholders alone, that will be a direct shareholder lawsuit against the corporation. But if it involves uh, the a larger breach by the corporation of its obligations, right, or it involves some corporate action that harms the corporation, or something allowing a third party to harm the corporation without board response, that's going to be a derivative lawsuit, and the shareholder is suing in their representative capacity. So a couple of other points about shareholders, right? So generally speaking, we know that a shareholder in a corporation is not liable for the um, the obligations beyond their capital contributions of the company, right? That there are a couple of exceptions to that, right? Um, Certainly, to the extent we know that, to the extent that they act as an agent of the company, right, they can be liable for their actions, right, in their agency, right? There's a liability there. Um, Other examples, if they acquire company shares for less than market value, that they can be liable for the difference in the price. And if they are majority shareholders, they actually may be in a fiduciary position with respect to the other shareholders, right? And that's an important point, because shareholders are not fiduciaries with respect to one another. Shareholders are owners of the company. They are to receive the benefits. They're beneficiaries of the company's profits, right? They don't automatically owe a fiduciary duty to one another. It is the parties who are acting on behalf of that company. It's trustees, if you will, right? We know them as directors, that are collectively responsible for being that fiduciary for the shareholders. But in some cases, the shareholders may have a fiduciary duty to other shareholders. This obligation arises when a single shareholder or a group of shareholders together obtain what or exercise what is known as de facto control, right? And that is simply just the actual condition of being a controlling group, right? Uh, and this would generally happen in a closed corporation. The obligation can also arise in a publicly held corporation. I've mentioned the Wall Street Journal sale of, the Bancroft family sale of the Wall Street Journal and Dow Jones to another conglomerate, right? They were not the majority shareholders. They were a special class. They had a special class of stock as the family of the founder, that gave them de facto say so over whether the merger took place. But because they had de facto control over the sale of the company, they too would have found themselves in the position of being a fiduciary to the other shareholders, right? In the decision with respect to how to, whether or not to sell the company um, in that transaction. So in the book's example, they say Brody, Jordan, and Barbara form a close corporation to operate a machine shop. Right? Brody and Jordan own 75% of the shares of the company, but all three are directors. After disagreements arise, Brody asks the company to purchase his shares, but his request is refused. A few weeks later, Brody dies and his wife Ella inherits his shares. Jordan and Barbara refuse to perform a valuation of the company, deny Ella access to the corporate information she requests, do not declare any dividends, and refuse to elect Ella as a director. All right? So Ella is going to allege that the majority shareholders have violated their fiduciary duty to her, and she's going to make an allegation that this is essentially what's known as oppressive conduct. And by not declaring dividends, especially, is like a huge red flag. Why else would you be a shareholder of a closed corporation with no market for the shares themselves, right? You're trying to get income, right? So Ella would likely have a very good case there. All right, so that is a specific fact pattern in which fiduciary duty does arise. In general, however, shareholders are not fiduciaries with respect to one another.